I will deal with the application for leave to appeal on both the judgment on the merits and the judgment on costs in this judgment. Section 17(1) of the Superior Courts Act 10 of 2013 provides that leave to appeal may be granted if the court is of the opinion that a. the appeal would have a reasonable prospect of success, or there is some compelling reason why the appeal should be heard, including conflicting judgment on the matter in consideration, or the decision sought will have a practical effect or result, and D. the appeal would lead to a just and prompt resolution of the real issues between the parties, even where the decision sought to be appealed against does not dispose of all the issues in the case. The applicant persisted with all the grounds of appeal set out in the notice of application and supplementary notice of application for leave to appeal, but argued the leave to appeal on a limited basis. In argument, applicant's counsel's main argument was that the court erred in its interpretation of the public protector's discretion, and that the result is that the court found that the public protector is not vested with the discretion in determining which complaints to investigate, and that the conclusion that the court came to is therefore incorrect. Mr. Botha referred to Minister of Home Affairs and Another versus Public Protector 2018 3 SA, SCA, paragraph 45 to 46, for his proposition that this court incorrectly interpreted the question of the public protector's discretion. If he is correct, there exists no danger that any court will be bound by this court's interpretation, as obviously the Supreme Court of Appeal has spoken, and there is accordingly no need that an appeal court should be burdened with this question again. However, the judgment should be read in its entirety with reference to the authorities as well as the factual context of the case. Regarding the question of the public protector's discretion, all the paragraphs dealing with this issue is relevant, and one cannot rely on 2 paragraphs only, as counsel did in his argument. I am not going to rehash what was said in the judgment. It speaks for itself. The principles applied were already dealt with in the Constitutional Court and the Supreme Court of Appeal. Reference was made in the judgment to all the relevant authorities at the time. In my view, the higher courts have already ruled on the principles, and these principles were applied by this court. After carefully considering the judgment as well as the arguments by counsel, I am of the view that regarding the judgment on the merits, none of the requirements of Section 17(1) of the Act were met, and therefore leave to appeal should not be granted. In any event, during argument, my attention was drawn to the fact that the public protector is, on instructions of Parliament, investigating the Estina matter again, which in fact then renders an appeal on the merits moot. As a result, it is not in the public interest that further resources should be spent on an issue that has become academic. Regarding the judgment on the issue of costs, this court has a discretion. In this regard, it is right that a court of appeal will not easily interfere with such a discretion. All the concerns raised by the public protector were considered, as well as the impact of a personal cost order against her. The court was guided by both the principles set out in the majority judgment and the views of the minority judgment in the Public Protector versus South African Reserve Bank. The court also took cognizance of several other judgments pertaining to costs and personal cost orders. Reference is made to those judgments in the judgment on costs, and those principles were applied. In the light of all the facts, I am of the view that in this instance too, the public protector failed to make out a case in terms of Section 17(1) of the Superior Courts Act. Therefore, I make the following order. The applications for leave to appeal against both the judgment on merits as well as the judgment on costs are dismissed with costs. Court will adjourn.